this, and this doesn't make sense. The bottom line is this, guys, and if agents that don't know about this, it doesn't matter, because there's an important group of people that do know all about this rule. It's the attorneys. And guess who the attorneys are telling about the rule? They're telling all the consumers. They're telling all the homeowners. So whether you like it or not, the attorneys are just salivating over the fact that now, if you're not in compliance, that you can get in trouble for it. So, so just remember what the like I said, what the main rule is for consumer protection. So hopefully that answered that question. Lisa said, let everybody know that she's going to be emailing out the zip form documents as well as those disclosures after the webinar. So she's going to make sure you get copies of those documents that you'll be using in future transactions. What about dual agency? Any tips on that? Well, the main tip on dual agency, that just means you have two agents from the same company or the same brokerage working on a transaction. It works the same way. Who's ever representing the seller is the one who has to be MARS compliant. Buyers agents, as long as they don't get involved in the short sale negotiation, they don't have to be concerned about compliancy. Okay, I think Lisa said that's it for questions for right now. So I'm going to go finish up with the last bit of information I wanted everybody to see. Let me get here. I want to call Beyond the Short Sale. And that is that there is a new non-deficiency law that just came onto the books effective January 1st of 2011. And the reason I think this is important is because up to now we've had a lot of confusion with regards to deficiency rules and regulations, statutes, as comparing foreclosures to short sales. Now, here in California, we do have non-deficiency for what we call non-recourse deeds of trust, which would be purchase money. But the law for non-deficiency relates only to foreclosures. In other words, if you're foreclosed on purchase money, then there's no deficiency rights here in California. Before January 1st of 2011, if you had a short sale, even on purchase money, deficiency rights were retained by all lenders on all loans. So we didn't have the law of non-deficiency for short sales. So this was big because all of a sudden now we can actually say, no matter what the letter says for the short sale approval, that by state statute we do have some non-deficiency rules here. So let's kind of go over those a little bit. So it's the new state law is SB 931, effective January 1st of 2011. It relates to residential 1 to 4 units. It doesn't matter whether it's owner-occupied or investment properties, as long as it's residential properties, 1 to 4 units. It's only regarding first trust deeds. So this has nothing to do with junior liens, but only on first trust deeds only, and it doesn't matter whether they're purchase money, refinances, whatever kind of loan it is, as long as it's the first trust deed. And then you have to have a written consent to the short sale approval. If all of those elements exist and you close your short sale, the new law states that irregardless of what the lender's letter says, the approval says, that here in California only, this is only California, it says the lender cannot pursue the borrower for any deficiency balance on the first. Remember, this is not junior liens, on the first only. Lender is obligated to accept sales proceeds as full payment, and then the lender can and will issue that 1099, because the 1099-C is a cancellation of debt, which means they discharge the debt, which is what we want on a short sale. We don't want them to say we won't issue a 1099 because then they can retain the rights of deficiency after that. So we want them to discharge the debt, issue the 1099. What it does not apply to then is junior deeds of trust. So anybody that gets shorted in a short sale on a junior deed of trust or a junior lien can still retain the rights of deficiency. So what do you have to do? You have to make sure that you either negotiate that away, make sure it's removed, make sure it's in the letter that they're not, they're eliminating or releasing their rights of deficiency, because if you don't get that in writing, then the lender can still go after the seller, and the statute of limitations for deficiency is 4 years. Also, if the borrowers committed fraud or respect to the sale of the property, they committed waste, what they call, damaging the property, then this statute for non-deficiency can go away. In other words, the lender can go after the borrower for deficiency if they, committed fraud. And then if the borrower is a corporation, they are not exempt from deficiency either. So that's a brand new law, just came out. It's good for us. We can go out and tell our homeowners that no matter what the lender says on a first, they're protected by state statute. You just have to make sure that you know what's going on if you've got any junior liens on that. Also, all right, let me see if we have any more questions here. Ooh. Let's see. For all advertising and signs, the font needs to be 2 points larger, correct? Yes, that is correct. But it's 2 points larger than the disclosure, not the size of everything else on the like you said, like on a sign, it says even larger than company name and phone number. It doesn't have anything to do with anything else is on the card or on the sign or whatever. It just needs to be 2 points larger than what the disclosure is. So in other words, if you make the disclosure as small as you can, which is like 6, then the font of the import notice has to be 8. But all the other fonts can be, 40. It's just the disclosure itself. Okay. If I'm calling clients regarding a foreclosure solutions workshop, do MARS disclosure rules apply? Absolutely. Absolutely. If you are advertising any kind of a community meeting, come in and we'll talk to you about your options, anything, absolutely, you have to give that disclosure. And the easiest way, like I said, the easiest way to do it is just say there's a brand new rule out, it came out from the FTC, it's for consumer protection. We want you to know that we are all about consumer protection and our company is completely compliant with MARS. So before we get started, I have to give you this little brief disclosure. And it's really easy. I'm not employed by the government. I'm not employed by your lender, and if you do use our services, we can't guarantee that the lender will accept the changes. Whatever it is, it's just that you're telling them their rights. And we should be good about telling them that they do have rights in a short sale. So hopefully that answers that. And whoops, hold on here. SB 931 apply to rental property? Yes, absolutely. It's residential 1 to 4 units. If there's no stipulation on whether it's principal residence, owner occupied, investment properties, there's no stipulation. So as long as it's 1 to 4 units, residential units, not commercial, and first trustees only, and you have a written approval on your short sale. Everything should is covered under the new state statute. Lisa's saying, let them know that Evergreen's printer has been notified of these rules. However, they are not real estate agents, so you are required to let them know when you need to add these to your marketing materials. Okay, hopefully I did that. I gave you that information correctly. Okay. All right. So I think we covered, like I said, we've still got a few minutes. If anybody has any other questions, I'll be glad to hang around and answer those questions. I also wanted to let you know that this has been like 30, 45 minutes of information. I have a 4-hour class, and we really get into a lot more information. It's really hard to give, a whole bunch of information in a short period of time, but I am holding a 4-hour class on half of MARS and all the new changes, 2011. If anybody's interested, I put the information up here. It's going to be in Seal Beach, and I think Lisa has the information also. It normally is $75 at the door, but for this group, if you said you were on this webinar, it'll be $65. Lisa, are you there?
Yeah, Vanessa, can you hear me?
I can. Hi.
Okay. And it's just so everyone knows, I will be emailing Vanessa's information out to you also. After the meeting, along with the other disclosures and everything, if anybody is interested in signing up. We did have, if you guys want to process through any other questions, I can go ahead and start reading them off. Anybody else who needs to leave the webinar, I'm assuming you're done other than that, Vanessa, or?
I think we've just about covered everything, so I'll just hang around for a few more minutes if anybody has any more questions. And And if anybody wants to contact me, they can email me or at the information that Lisa's going to give you. And I also have like a bullet point of some Mars that if you're interested, I can send that to you also.
Great. I have a question here that came up. It says, if you handle short sales but do not seek them out via advertising, do the disclosures need to be followed other than with the individual client you are representing in a short sale?
Well, if you're not seeking them out, in other words, depending on how you get the client, if they call you, or or they email you, or they contact you through your website, then the minute you contact them, then you need to give them the disclosure, as far as that you're not affiliated with the government. I hope that makes sense.
That makes perfect sense.
That's why, like on your website, if you have on your website a specific, let's say you have a tab for distressed homeowners, or if you're interested in short sale information, on that portion of your website, you better have your disclosure information. If they call you and they say, I heard from a friend of mine that you handle these types of transactions, before any other conversation, I need to give you this disclosure. So I hope that's what you meant as far as, now if you're door knocking or something like that,
right?
If you're door knocking and you meet somebody and they say they're having an issue and they want to talk to you further, you have to give them the disclosure. If you're handing out brochures, if you're putting door hangers on, anything that would be getting to the general public that says anything other than I sell property, I list property, and that's it. You do anything to do with distressed homeowners or short sales or preventing foreclosure or giving them their options, anything, then that has to have the disclosure on it.
Someone asked, are Spanish forms available? For zip forms, you would actually have to call zip forms. I would imagine they probably do.
Yeah, I think CAR already has those forms where you can go in and push the button and translate it into Spanish. So those two forms I think are available in Spanish.
Another question, I get referrals from an attorney. Do I need the Mars forms?
Yes, if you're getting referrals from the attorney, he needs to have Mars forms. You need to ask him if he's being Mars compliant. And then if it's a referral, once you take over that transaction, then you have to be Mars compliant.
Perfect. I would say to anyone, if you are at all involved in anything having to do with the short sale, use the forms.
Absolutely.
It's easier than trying to figure out where you don't need to use it. It's just to try to use it at any situation where a short sale is involved.
Yeah. And I totally agree. And there's a lot of conversation going on right now where they're saying, oh, this probably won't last. NAR is still fighting with the FTC to say, because the language is a little unusual for real estate, and they're trying to get it to be more specific to real estate. So, 30 days, 3 months, 6 months down the road, they may change this, they may move it around, but it doesn't really matter at this point. As of today at 1 o'clock or whatever, this is in effect. So, cover yourself. I am always much more involved in over-disclosing than under-disclosing. This is for your protection.
I think
so you don't want anybody coming back and saying, I did a short sale, and they're going to ask, well, did you happen to hear this disclosure? Did they give you that paperwork? And they go back to you, and you go, well, I didn't think it was that important, or, you don't want to do that.
Yeah.
So just over-disclose. Always over-disclose.
That's it. We don't have any other questions, Vanessa, so I'm going to stop the recording now. Thank you, everyone, for attending. So we'll be closing out the webinar at this time, and you'll be receiving an email here today with a lot of the information that we got here.
All right. And if anybody comes up with any more questions, you can send them to Lisa, and she can forward them on to me, and I will be glad to answer them.